Okay, so welcome everyone. I hope you had a restful break. You're full of energies. So my name is Antonino Salmeri, and today I'm here to talk to you about legal and policy aspects of space resource activities. So as you can see, I'm in a very difficult position here because you heard of amazing space telescopes, you heard about Earth observation and radar, you've seen very interesting presentation with lots of pictures, and here's the lawyer to talk about the boring legal stuff. So apologies for that. I'll try to be as interesting as possible. I have no pictures, so I hope you'll forgive me. Uh, and with this, I guess we can start. So we can skip the bio. I mean, Eric was already very kind with his introduction. What I'm going to talk about today. First of all, I assume not many of you know space law. So what I will do is try to introduce space law for you in a very hopefully understandable way. Then we're gonna talk about space resource activities. I also realized as I was listening to the presentation that I should probably mention what space resource activities are in a few words, because again, not many of you are probably familiar with it. Then I'm gonna leave you with some open questions and recent developments that could hopefully be helpful for the roundtable, because we're gonna talk about developments in international policy and diplomacy, and this is exactly at the core of my job. So, first of all, what is space law, right? It exists to begin with. There is a corpus of law regulating space activities. It's what we call, because we space lawyers love Latin, corpus juris spatialis, which is essentially a group of customary law, which are provisions that are binding the entire international community by the fact that they are always been adopted. So it's something that happens by means of custom. Then we have 5 treaties, all concluded before. I mean, in the time where we started space activities, and then we went on the moon. So between the 50s and the 70s, and then we have a number of UNGA resolution. UNGA stands for United Nations General Assembly, which are more of guidelines that you can imagine on implementing this binding provision. So the binding legal part is the treaties and the custom law. The most important source you have to remember today is the Outer Space Treaty. It's what we call, again, we love Latin, the Magna Carta of space law. It's essentially a treaty on principles. We will go through them in a second, which will tell you the very basic of how do you explore and utilize outer space. So essentially, the purpose of space law, the purpose of the Outer Space Treaty, is to allow amazing people like Begonia and Matteo to do their job, right? To explore space, to utilize it for the benefit of humankind, and in essence, to allow humanity to continue expand. I like to think of space law as an enabler in this regard. So it's a legal regime at the really interaction between law and technology. What we're doing here is trying to also regulate something that doesn't even exist. We imagine that when the treaties have been concluded in the 60s, 70s, nobody had an idea of what we could do with space in practice. We had no idea how far we could go with technology, and still we had to provide rules that would work also for the future. The Outer Space Treaty is from the 1967, but I can tell you it's still, kicking asses, and it's a good treaty because it was done with this forward-thinking approach. The defining features of space law are international cooperation and peaceful uses. I want you also to remember these two concepts because space is big, it's difficult, and it's something that we all share. And again, the founders of international space law knew that very well. And so even though when you think about the development of space, you hear the space race, the competition between United States and the Soviet Union, that is a part of it, but that rhetoric was not into the space law. So when the states sat down at the United Nations to make the rules for space, they were not thinking of a competition, they were not thinking of conflict, they were thinking the opposite. How can we cooperate together in space? How can we ensure that we do not make the mistakes that we have done on Earth in that environment? And how the law can help into that. So that's essential. The problem is that, not a problem, but the reality is that when space law was developed, it was about states. It was about state activities, big satellites, few activities. Everything was easily controllable. And then companies came in, companies like Airbus, as you've heard. And that changed the way we approach space law, because of course certain rules that are fine for a state are not for a company, and vice versa. So one of the challenges of space law today is how do we adapt to the privatization of the space sector, what we call new space movement. And to do that, there's going to be an increasing role of national space legislation to regulate these activities. So the majority of space law is done at the international level, but this is not enough when you're talking about regulating companies, because companies are based on a certain jurisdiction. They have to be regulated at the national level. So we need to understand how we can move space from an international, primarily perspective, to a multi-level governance, which is also the topic of my PhD. So hopefully I'll find out how to do that. So the fundamentals of space law, those are the rules that apply to all activities, no matter exactly what you're doing. So you can be doing the James Webb Space Telescope, or you can be doing radar observation from space. These rules apply to you in any case. The first one is the most important. It's the golden rule of space is that it is free. Free for everyone, every state to be precise, to explore and use. So this is a fundamental principle. If you think about it, it should not be taken for granted, because, for instance, the rules governing the airspace, which is just below space, are the opposite. It's sovereignty. Each state decides whatever they want to do. They own it. They do whatever. Space is different. It's free. It means that we all have to share it, that we have to be mindful of each other in space. To protect the freedom of outer space, Article 2, it's another fundamental principle. It says nobody can appropriate it. No state can go, and this was especially important. Imagine this was 1967, and the United States and the Soviet Union were in a competition to go to the moon. But none of them thought, I'm going to the moon, I'm going to put a flag, and this will be mine. You know, the desire could have been there, but they didn't think about it. They said the opposite. We want a rule that says whoever arrives there first doesn't own anything. This will still remain open for everybody to be explored and used for the benefit of humankind. So that's a really forward-thinking approach if you think about it. And again, looking at how we behave on Earth, it was not taken for granted that we have managed to keep this principle in space. But we do, and it's one of the most important ones. To ensure that these rules will be upheld, we also said that international law in general and the UN Charter are applicable in space. This is a fundamental provision, because sometimes you may hear that space is like the far west, or you may hear people like Elon Musk saying that Mars is a free planet outside any jurisdiction. That is not true. International law applies in space, and the reason is that we want to protect space. We want to protect space as an environment where the rule of law still continues. So the obligation you have on Earth will also be relevant when you do space. You cannot go to space and escape your international obligation or the rule of law. Space is fully subject to that. Continuing into this line of direction, there are the peaceful purposes of space. Again, as I said before, peace was one of the main objectives of space law, and it still is. There was also another fear of the superpowers. It's like, let's not put nuclear weapons in space, right? That they imagine in the 60s, this was the real danger of a nuclear war. If somebody could put a nuclear weapon orbiting space, it could have the power to destroy the entire world at any time with catastrophic consequences. So they said, let's not do that. And there are different rules. I'm not going to go into details, but there are different rules on using orbit, because orbit is a more strategic environment that could be used for certain military purposes. So not to do war in space, but for instance, to use the satellites that Matteo described before to support military operation. And this happens every day. So with satellite images and radar communication, we know exactly where to hit a target. So this is military uses of space that is very clearly allowed under space law, because of the strategic value of the orbit. But there are limits, so you can use it to support, but you should not shoot a laser to each other in space or put any nuclear weapon. Celestial bodies are a different story. They are bound by the exclusively peaceful purposes, and we will see that when we'll talk about space resources. And then there are a bunch of other provisions which say that essentially every time there is an activity in space, a state is responsible for it, meaning that if something goes wrong, it will be that state that will pay the consequences of it. Then a state will be liable, and it's not the same. I am Italian, and in the Italian language, we don't have the legal distinction between responsibility and liability. Most of you are from Spain, so you probably don't have the same. But in English and in legal English, responsibility means bearing the consequence of something. Liability means that you will pay for those consequences. So this is a critical difference. The responsible state and the liable state are not always the same, because the responsible state is identified based on the jurisdiction. Who has jurisdiction on a certain activity? The liable state is the launching state. So for instance, the James Webb Telescope will be launched from French Guiana. That means that France will be liable for any damage that eventually could happen because of the James Webb Telescope or during the launch. And that is even though France has nothing to do individually with that, simply because they're the launching state. And then the responsible state will probably be the United States, because it's the one that is exercising jurisdiction over the scientists that operate the telescope. And then this is also had to do with registration and formally acknowledging that you are exercising certain control over an activity or an object. And then Article 9 is a final provision I will mention you today. It's a fundamental provision. It's what I call the systemic key of space law. It puts states in front of each other, and it says that whatever you're doing with space, you have to do it with due regard. This has to do with the fact that space is free for exploration and use, and as you very well know, our freedom ends where the others begin. And the same is in space. If everybody would be free to do exactly whatever they want, then nobody could exercise space. Everything would be threatened because the limit would be absolute. So due regard means, yes, you're free, but keep in mind that there are others with the same or different interest, and you have to be mindful. And if there is any problem, you have to consult. And this is what Article 9 says. And finally, there are some provisions on environmental protection of space, which we could definitely do better. And so that's going to be an area that we will try to improve at least. Now, before I go into the implications of this principle on space resource activities, I want to spend a few minutes on what space resource activities are. You have heard about presentation mentioning what we call space application, or let's say space exploration into a more scientific sense, but again from Earth. Space resources have to do with space exploration and deep space exploration and the expansion of the human civilization in outer space. What is the critical role of space resource is that through space resources we can reduce the cost and increase our effectiveness when we operate on other celestial bodies. So please don't think about space resources as something, let's go to mine an asteroid, take gold and bring it back. That's not economically or scientifically very feasible. It's super expensive and very complicated, also unnecessary if you think about it. But what we want to do with space resources is, let's say we're going to go on the moon. And you probably heard that many countries now want to go on the moon and explore it and have a sustainable presence. Now, if you have to bring everything with you, everything you need from Earth, it's going to be not feasible. Again, as you heard before, the majority of a rocket is fuel. And the problem is that to bring stuff in space, we have to have a lot of fuel and we spend money. And so if you have to bring tons of materials with you, you're not going to be sustainable exploring space. You're just going to spend a lot of money and your abilities will be reduced. So space resources are there to help us. So when we go on the moon, we don't need to bring the oxygen, the water, the materials with us. We use what's on the moon. And there is a lot of ice, for instance, there we discovered that we can use to then make water, to then make oxygen breathable for the astronauts. We use the regolith to build infrastructure. We don't have to bring everything with us. So that's the critical role of space resources. They're going to be a fundamental component of a new type of exploration, which is less expensive and more sustained and sustainable. The issue is, how do we regulate that? Because, of course, space resources are a very critical and topical subject in international space diplomacy because they are in any ways limited. And so the question becomes, if we are all free to explore and utilize space, if space is to be used for the benefit of all humankind, then how come you can go and exploit a resource individually, right? How come is this not national appropriation? And there are many questions that I will point out at the end. So the very first question that actually happened when we thought about utilizing space resources in space exploration was, is this legal? Can you do it, right? Because as I said, there is a principle that says you cannot appropriate space. The question is, yes, it is legal because you have the freedom to utilize space. And the freedom of utilizing celestial body essentially means that you can make use of the resources that are there. So yes, you can do it. And no, the non-appropriation principle does not apply to space resources, and we will see what is the legal difference. However, the freedom to utilize space and to utilize celestial bodies is not absolute. As I said, there are many limits to consider. The most important ones being the fact that you have to share the benefits of space activities, including space resource activities, that this has to remain what we call the province of humankind. So it's an activity that should not be only for the rich or the powerful, but should be for everybody and should be done, with the interest and benefits of all countries in mind. And the fact that celestial bodies shall remain accessible to every actor that wants to go and explore them. So yes, you can do space resources. No, it does not constitute appropriation. Why? Because the non-appropriation principle was meant to avoid that the state would expand its sovereign control in space. So it does mean that you cannot go to the moon and have another part of the United States on the moon or the Soviet Union. That means that that is not possible. But at the same time, when you go on the moon and you extract a resource and you separate it from the celestial body, then you can appropriate it. But the fact that the territory where you're operating will still remain not yours. It will still remain not under your exclusive control, meaning that you will have to share it. To do that, of course, it is fundamental that all the actors in space resource activities will respect international law and will not threaten international peace and security. Because again, we do space for peace, not for war. And that it goes into the fact that space resources shall be used for exclusively peaceful purposes. This is a fundamental principle because you probably have already heard that there are let's say, corps in certain countries like the United States, the Space Force, and this kind of military rhetoric. We can talk about it in another occasion or during a break, how much of that is really true and how much is just rhetoric. But the important thing is that you cannot, legally speaking, take the resources of space and use them in military application. So that is a fundamental difference between exploring space in orbit and exploring it on a celestial body. You cannot take the resources on the moon and use them for military purposes. That is prohibited. So the application of space resources are limited to civilian application, commerce, science, business, anything you can imagine, but not military. Other further implications are more into the legal side, so I'll be brief on those. Essentially, that means that the licensing state will be responsible for the space resource activity that it licenses. At the same time, there will be launching states liable for the damage caused. There's going to be a registration state to exercise jurisdiction and control to make sure that all the rules are respected by the individuals. And all of these states will have to pay due regard to each other. Meaning that, again, they cannot behave as if they are the only one there. They have to be mindful of what can happen in the future and how their own operation is impacting the ability of others to conduct similar or different operation. And those states have to consult with each other if there could be interferences. And I can tell you there can be many of them. Imagine that, for instance, if you're mining the south pole of the moon to get ice, and then a starship is landing close to your operation, your entire activity will be blown up. Because landing on the moon, for instance, is an activity that creates a lot of interference. There is a lot of dust generation. There is a lot of shaking the surface. So if Elon Musk will just go and land, or Jeff Bezos for what it's worth, and doesn't tell you that it's coming, or does not consult about it, and come close to your area of operation, you can just give up and you're going to lose all the results. So states will have to consult and prevent these interferences to happen by means of diplomatic consultation, and then in the future, mediation and arbitration if there is any conflict. To do that, there is critical process which is about information sharing. If states that intend to do activities, and especially space resource activities, inform the UN of the nature, location, duration, and result of the activities, we can already avoid the main problems at the beginning. This is a provision that I didn't mention before. It's Article 11 of the Aerospace Treaty. I didn't mention it because it has never been used, essentially. This provision says that states agree to share information. Now, as a lawyer, I will tell you that when a state agrees to do something, it means it's not bound by this. It says that I'm very kind, so I will do it, but if today I don't want to do it, you can do nothing about it. And so that's why Article 11 has never been used much. There's been 20 submissions over the last 60 years under Article 11. Because states didn't see the value in sharing the information. At this point, though, I'm one of the advocates saying that we should change our mindset and use this provision because it's helpful. Because you realize that sharing information is in your own interest to prevent interferences. Now, there are many open questions related to space resource activities. And those are the key ones. I'm not going to answer those because, of course, this is exactly what we're trying to do today and eventually in my work and with other organizations. But you have to imagine that we really have to think about many things and re-challenge the way we understand space law and international law and the interaction between public and private activities. And the most important one for me is still to guarantee the peaceful and sustainable uses of celestial bodies like the moon. They're precious to humanity, and so we don't want to screw them up, right? So this is, for me, it's the one that we need to answer. We don't want conflict on the moon, and we want the moon to stay utilizable for future generation. So this is also at the core of the activities I do for Space Generation Advisory Council, is that we as the next generation of space explorers, we want to have a say in how these are utilized because we're going to be the one inheriting the consequences of that. And I have to say, the space community, differently than the Earth one, is much more open to this kind of discussions. Finally, this is just an overview of the recent policy developments that you may want to look at. The first one is the Hague International Space Resources Governance Working Group. That's a very long name. This was a very nice experiment. It was a multi-stakeholder consortium created in 2015, operating for 4 years, and creating what we call building blocks. These building blocks are essentially the fundamental things that we need to keep in mind when regulating space resources. And so the work of the Hague Working Group has been critical for the international discussions we're having today. The evolution of the Hague Space Resources Working Group is a global expert group on sustainable lunar activities, which is specifically focused on how do we explore and utilize the moon, including its resources, but not just limited to that. And so this is what I'm trying also to do with Space Generation Advisory Council. The EAGLE team that Erik mentioned before stands for Effective and Adaptive Governance for a Lunar Ecosystem. So we're a group of 14 young professionals advocating for the sustainable use of the moon, and we developed a report that we essentially complement the Hague Space Resources Working Group and the Global Expert Group. And then there is also another entity called the Open Lunar Foundation. They organize a series of webinars called the Moon Dialogues. I would encourage you to look at them on the internet, which are meant to bring this policy discussion to the general public, as we're doing today, and get feedback and cross-contamination among different fields. The 4 flags that you see there, and I'm about to end because I promised to be brief and I didn't make my promise, so apologies to Erik for that. These are the 4 states, the only 4 in the world, that enacted national legislation for space resources. So the United States was the first in 2015. Then Luxembourg followed, 2017. That's why they're paying my PhD. They're interested in that. Then Japan, very recently, and then the United Arab Emirates. Those 2 over the last 2 years. Finally, these are what we call unilateral approach. So this is what the United States government will do to regulate this at the national level. At the same time, we need to also coordinate this regulation to make sure that we can avoid tensions. And so this is done at the regional level by documents like the Artemis Accords or the International Lunar Research Station. Those 2 are 2 programs for the exploration of the moon. One involves mostly Western countries. The Artemis Accords is United States and partners like ESA, Japan, all the countries you see there essentially. And then the International Lunar Research Station is a project initiated by China and Russia, and they're looking for international partners as well. Both these programs will be regulated by certain documents, which are meant to provide coordination among the partners. But the most important part, sorry, I think the computer blocked here, okay. The most important part here is that we need to think different, right? The idea is really that these problems are innovative, and so to solve these problems, we have to be innovative as well. And so creative solutions are needed, and those cannot come only from the law, they need to come from a multidisciplinary approach. And so here you can see some of the examples that we are thinking to propose, but they can only come if we integrate the legal and policy development with the technology, with the economics, in order to understand that this is not something that a single expert can solve. We need a group of people from different backgrounds and different entities. And this is what the United Nations is working on. Right as we're speaking, there are meetings of a newly created working group on space resources that was created a couple of months ago, and it's meeting for the first time as we speak today during the plenary meeting of the United Nations Committee on the Peaceful Uses of Space. And so this working group just started, and on a 5-year plan will try to come up with principles that can ensure that space resource activities are done in compliance with space law. So in conclusion, this is a quote from a very famous man, Roosevelt, and the idea is really that to get something you never had, you must do something you never did. Sorry, it was Thomas Jefferson. And so in principle, space resource activities are permitted. We have the legal framework to do that, but we have never done it. So we need to create and to be evolving also from the legal perspective in order to do something that indeed we have never done. And to that, multilateral, multi-stakeholder, and multidisciplinary debate is the key. We need to involve everybody, also people not from the space field. So that's why I'm very happy to be here today, because indeed we need those type of cross-contamination. I think success or failure will depend on our ability to innovate and renovate. We still have time to succeed, but it is time to act. And so I'm very happy to continue this discussion. And I would like to thank you for your attention.